Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here this evening to get prepared for Mr. Kelly's sentencing, which is supposed to take place tomorrow. For some reason, I thought it was later in the month, like the 25th or something, but maybe the 25th is the weekend. I'm not sure, or Friday. But in any event, his sentencing is going to take place tomorrow. So I am going to read through some of these documents that I told you all last week that I had pulled that will prepare you for the sentencing that is going to take place. And if you are new to this channel or don't have any clue what I am talking about, this is the sentencing for Robert Kelly in the Northern District of Illinois. He was found guilty on several counts of a 13-part indictment in the Northern District of Illinois. And if you want to get caught up on that, you just need to go through videos on my channel, because there is a whole bunch of them out there, so that you can follow both the Northern District of Illinois case and the Eastern District of New York case. Now, it's going to be very interesting to see how Judge Lynn Weber rules on this, because as those of you who've been following the case know, that Mr. Kelly has already been sentenced to 30 years in federal prison from his guilty verdict in the Eastern District of New York. And in the Northern District of Illinois, they are asking for 25 years, and they want it to run concurrent. No, they want it to run consecutively. I'm sorry. Concurrent means that you're running at the same time. Consecutively means that they want him to do the 30 years in New York, and if he lives to tell about it, then he'll serve the sentence in the Illinois case. And it's really difficult to kind of anticipate how the judge is going to rule, because he definitely was no Ann Dunley. So he can go either way with this. He might, go along with the 25 years, but then say, but it's going to be concurrent. Or he might, say that consecutive. And in that event, I did read an article where they said that he would basically be 100 years old by the time he was able to get out of prison. But we are going to backtrack here for a second. And we're going to go back to the sentencing memorandum that Jennifer Bongine put out. And she put this out a couple of weeks ago. And we'll pick up there and go through what's going to take place tomorrow. And then I can backtrack and go to some of the other documents that I pulled that I said I was going to share with you guys. So once again, this is a sentencing memorandum, and it's from Jennifer Bongine. It is a pretty lengthy document. So let's go ahead and get into it. It starts out with an introduction. It says, Robert Kelly, 56 years old, is currently serving a 30-year sentence of incarceration dispensed by the United States District Court for the Eastern District of New York in connection with the case United States versus Kelly, 19 CR 286. A 30-year sentence of imprisonment for an African-American man with diabetes is a life sentence, statistically speaking, because the crimes for which Kelly was convicted in his prosecution could have or should have been brought pursuant to the Eastern District of New York Racketeer Influence and Corrupt Organizations Act RICO prosecution, significant incremental punishment is not warranted, particularly where Kelly is already serving a de facto life sentence. As fleshed out below, the Eastern District of New York prosecution charged Kelly with RICO under a theory that he engaged in a pattern of racketeering activity between 1994 in 2018 as part of an enterprise that had the purpose of recruiting young women and girls to engage in illegal activity and to produce CP. Example, and then she says Eastern District of New York superseding indictment. At paragraph 2, the charges brought in this district could have been brought in the Eastern District of New York indictment since the conduct alleged in this prosecution occurred during the relevant time period and was covered by the purpose of Kelly's alleged RICO enterprise. Kelly faced a guidelines range of life in prison in the Eastern District of New York case and was sentenced to 30 years. As a matter of fairness and double jeopardy, Kelly should not face consecutive sentencing where piecemeal prosecution by the federal government was designed to unfairly enhance his punishment. The federal government's obsession with Kelly, that Kelly dies in prison, is particularly troubling, where it seems to have no appetite for investigating or initiating prosecutions of numerous other famous white musicians with credible histories of abusing underage individuals. And then they have a note at the bottom: United States Sentencing Commission preliminary quarterly data report indicates that a person held in a general prison population has a life expectancy of about 64 years. People versus Buffer. United States versus Nelson, which was a case heard in these. Okay, so Buffer was heard in 2017 in an Illinois appellate court, first appellate court. And then United States versus Nelson, 7th Circuit in 2007, acknowledging the decreased life expectancy for incarcerated individuals based on United States Sentencing Commission data. As set out below, Kelly accepts that he faces a mandatory prison sentence of 10 years in connection with his conviction here. However, Kelly contends that his guidelines range is 135 to 168 months imprisonment. The government inappropriately places the range higher at 168 to 210 months imprisonment on the erroneous claim that the inducement counts carry higher adjusted offense levels than they do. Because Kelly did not use physical force, threats of force, or tactics, instilling fear in Rishona, Pauline, or Nia to gain their compliance in the prohibited conduct, the government's efforts to artificially raise the offense level of the inducement counts must be rejected. And somebody sent me a link, and y'all know my memory is so bad, because so much time has spread out. But I did have the name of one of these chicks. I think it was the Pauline chick. Was Pauline the real sassy one that kept getting smart and tried to extort the $32,000? Yeah, I think her real name is Shamia or Shamira or something like that. I'll have to pull that up and get the correct information. And it was so interesting that on her social media, she didn't even post about the trial or going to the trial or anything like that. Just went on about her business like it was, just another day at the beauty salon. So anyway, it goes on to say, when considering the factors set forth in Title 18 United States Code, Section 3553A, including Kelly's significant mitigation evidence and the fact that he is already serving a 30-year sentence for a pattern of racketeering activity, quote unquote, that could have included the conduct alleged in the Northern District of Illinois indictment, a concurrent sentence at the lower end of the guidelines range is sufficient, but not greater than is necessary to comply with the purposes of sentencing. A consecutive sentence would serve no specific deterrent, as Kelly is likely to die in prison either way. Oh, child, don't be speaking that negativity over that man's life. Even if he beat the statistical odds, he would not be released from prison until well into his 80s, long after he is a threat of any kind to the general public. A consecutive sentence serves no general deterrent purpose either, at least no stronger purpose than what has been accomplished with his Eastern District of New York sentence. Since the government and society at large have served a unique, unprecedented contempt for Kelly that is wanting as to his similarly situated white counterparts. In fact, iconic white musicians like Elvis Presley, who married his 14-year-old girlfriend, are currently being celebrated in Academy-nominated movies. In contrast, the government argues that one life sentence isn't enough for Kelly. No one will be deterred by a consecutive sentence in this case because no one believes that they will ever face the punishment Kelly has faced for the same exact conduct. All right, Bonjean, tell them how you really feel. So the court is asked with sentencing Kelly to an appropriate sentence that addresses the harms a jury found he caused, but an appropriate sentence is a lower guidelines range sentence run concurrent to the Eastern District of New York case, which is the functional equivalent of a life sentence. Such a sentence punishes Kelly for conduct that is over a quarter century old while taking into account his individual characteristics that include his own horrific child abuse that shaped him and provides some explanation, not an excuse, for the conduct that underlies his convictions in this case. Brief factual background. Kelly was convicted of 3 separate offenses of Title 18 United States Code Section 2251A, stemming from the creation of 3 videos depicting conduct with Rishona, who testified that she was a certain age at the time the videos were created, 14 that is. Defendant was also convicted of violating Title 18 United States Code Section 2422B as to Rishona, with whom he had a relationship that lasted roughly 12 years. The jury returned 2 additional guilty verdicts for violations of Title United States Code Section 2422B as to Mya and Pauline. Mya testified at trial that Kelly fondled her in a hallway at his studio on a single occasion when he was 29 years old and she was either 15 or 16. Mya testified that the isolated encounter occurred the summer of 1996, but she could not state precisely when the incident occurred. Pauline testified that she began engaging in conduct with Kelly when she was 15. The prohibited relationship endured long after Pauline became an adult, and she considered Kelly her boyfriend. Kelly was acquitted of all remaining counts of the indictment. So then she goes into her argument, and it says a district court should begin all sentencing proceedings by correctly calculating the applicable guidelines range, which should be the starting point and the initial benchmark. Gall versus United States, which was a case heard in 2007. After proper calculation, a sentencing judge considers the 7 factors set forth in Title 18 United States Code Section 3553A. The nature and circumstances of the offense and the history and characteristics of the defendant. The 4 legitimate purposes of sentencing as set forth below. The kinds of sentences available, the applicable guidelines range itself, and relevant policy statement by the Sentencing Commission. The need to avoid unwarranted sentence disparities among defendants, and the need to provide restitution to any victims. Title 18 United States Code Section 3553A 1 through 7. So in determining the appropriate sentence, the statute directs judges to impose a sentence sufficient but not greater than necessary to comply with the purposes of sentencing, which are A, to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense. B, to afford adequate deterrence to criminal conduct, C, to protect the public from further crimes of the defendant, and D, to provide the defendant with needed educational or vocational training, medical care, or other correctional treatment in the most effective manner. Title 18, United States Code Section 3553A2 is where you can find that information. So, 1. The guidelines sentencing range is 135 to 168 months imprisonment. Defendant's guideline range for the instant case is 135 to 168 months imprisonment, not 168 to 210 months as the government argues. Then there's a note at the bottom that says the range is certainly not as probation contends, where probation clearly did not read the testimony of the complaining victims, ripped much of the PSR from the Eastern District of New York case, and demonstrated a concerning bias where it attributed a criminal history point to Kelly based on, let me go down to the bottom of the next page, or is it the next page? Okay, where does she finish her note? Okay, so she didn't finish her note. Not sure what happened there. Oh, here it is. Let me see. Yeah, y'all hold on. Bear with me here. Okay, based on an unsourced internet article, in its recommendation of a maximum guideline sentence, probation did not even accurately summarize the conduct of which Kelly was convicted. For example, probation summarized conduct related to Mya that was neither pled in the charging instrument nor related to the count for which Kelly was convicted. Probation claims that Kelly's conduct against Mya was, quote, not a 1 or 2-time occurrence, end quote, when it was precisely a 2-time occurrence and did not involve anything more than touching. In its recommendation, probation relied heavily on facts that a jury expressly rejected and even invented facts that were never alleged by anyone. A jury rejected the government's evidence that Kelly enlisted people to retrieve contraband. The jury acquitted all 3 defendants of receiving CP, which demonstrates that the jury clearly rejected the government's claim that Kelly enlisted persons to obtain any tapes. Probation seems to have blatantly ignored the jury's verdict to the extent that it benefits Kelly. Probation even boldly claims in its recommendation that Kelly began, quote-unquote, blackmailing Rishona. This is nothing short of a fabrication. In sum, probation did not do its job. It demonstrated extreme bias and a lack of competence in putting together the PSR. Its recommendation should be ignored. Ooh, child, and I agree. If they in there lying and shucking and jiving, it needs to be put aside. So that was the end of the note that was at the bottom of one of the pages and continued on the next page. And it basically explained Jennifer's comment that they put an incorrect range in the sentencing guideline or sentencing memorandum. So then A, ex post facto, the government advocates application of the 1997 federal sentencing guidelines. Kelly agrees that the 1997 sentencing guidelines should apply since the conduct for which defendant was convicted occurred prior to November 2000. Probation applies the 2000 sentencing guidelines. Probation applies the wrong guidelines, but it does not seem to impact the guidelines range. B, offense levels. 1. Counts 1 through 3. The CP counts. Base offense level was 27. Adjusted offense level 29. Defendant agrees with the government that the base offense level is 27 pursuant to guidelines in Section 2G2.1a. Defendant further concedes that a 2-level enhancement is appropriate pursuant to Section 2G2.1b1 because Rishona was over the age of 12 but under the age of 16. This would be true whether applying the 1997 or 2000 guidelines. 2. Count 9, inducement count as to Rishona. Base level is 15, adjusted level is 15. The base offense level for this count is 15, pursuant to sections 2G 1.1C3 and 2A3.2. The parties agree that the starting point for calculating an offense level for this inducement count is section 2G1.1, but the parties disagree on which cross-reference subsection applies, if any. Section 2G1.1, C2 and 3 reads as follows. So number 2 reads, if the offense involved criminal abuse, attempted criminal abuse, or assault with intent to commit criminal abuse, apply section 2A3.1. Criminal abuse, attempt or assault with intent to commit criminal abuse. 3. If the offense did not involve promoting prostitution and neither subsection C1 nor C2 is applicable, use the offense guideline applicable to the underlying prohibited conduct. If no offense guideline is applicable to the prohibited conduct, apply section 2X5.1, other offenses. So the application notes provide that the cross-reference at section C3 addresses those cases where the offense did not involve promoting prostitution and neither C1 not C2 applicable, and includes such prohibited conduct as criminal abuse of someone under 18, United States Code section 2243A. So contrary to the government's position and the position of probation, Kelly's contact with Rishona did not involve an offense of criminal abuse or aggravated criminal abuse, as defined by federal law and the law of this circuit, since it did not involve force or threat or force or the use of fear to engage Rishona in the prohibited conduct. Accordingly, cross-referencing to section 2A3.1 is prohibited. Now, I went back, and you guys that have been following me for a while and know that I have all these documents that I haven't read, especially the testimony from all of the testimony from the Northern District of Illinois case. But I was reading the mom's testimony, and I'm going to do a video on it, where it seems like they knew exactly what was going on from day one, that they kind of encouraged it, from what I was reading from the testimony. And the mom's testimony also contradicted a lot of what Rishona said as far as ages. Remember, Rishona said she was 12 when Sparkle introduced her at the performance, but in the mom's testimony, she says that Rishona was 14. And then in Rishona's testimony, she said it was 2 years after she met him that stuff got started. So applying that rule, then the 2 years would have been 16, right? If the mother is telling the truth. So some contradiction and conflict between this testimony that was going on. But in any event, I do agree that there was no coercion, no threats or anything. This seemed to have been very calculated, and she seemed to be very willing, regardless of the age of consent, of when a person can consent or whatever. Definitely should not be punished. Be punished because you violated the age of consent. But I don't think you should be punished if you didn't force the person or coerce the person if they were a willing participant. So, and then I like the fact that she referenced the whole Elvis Presley thing, but I read somewhere where once again it stated that he met, and I didn't watch the movie, didn't go to the movie, because I was like, the nerve of them to be having a movie about Elvis Presley and this woman, right? when you have the whole Me Too thing going on where they're condemning this type of behavior, even though it was very commonplace decades ago, but you're condemning that behavior, but then you let this movie about Elvis Presley come out where they're like trying to change the narrative and everything and say, oh yeah, he met her at this age, but their relationship didn't start until later on. So it's just all kind of crazy to me. But anyway, we're going to move on. So Section 283.1 of the Sentencing Guidelines applies when a defendant has committed the offenses under Title 18, Section 2241 or 2242, the USSG Section 243 Sentencing Guidelines, United States Sentencing Guidelines, guys. Section 283.1 comment. A violation of Title 18 United States Code Section 2241, also known as aggravated abuse, can be reached when a person knowingly causes another person to engage in an act by using force against that person, by threatening or placing that other person in fear that any person will be subjected to death, serious bodily injury, or kidnapping. Section 2241A, and that comes from 2241A, I'm sorry. Force is the exertion of physical power upon another to overcome the individual's will to resist. United States versus Cates, that was heard in the 7th Circuit in 2020. With emphasis added. The 7th Circuit has expressly rejected any interpretation of force to mean psychological coercion rather than physical force. In regards to Cates versus United States, 7th Circuit 2018, emphasizing that in order to convict an aggravated abuse, the jury must find the defendant used an actual physical force against the victim or made a specific kind of threat like fear or death, serious bodily injury, or kidnapping. Section 283.1 of the Sentencing Guidelines would also apply if Kelly committed a violation of Section 2242 of the United States Code, Title 18. Notably, the government did not charge Kelly with a violation of Title 18, Section 2242, and a jury was never asked to decide whether the elements of abuse were satisfied. A violation of Section 18 of Title 18, Section 2242, also known as abuse, requires the government to prove that the defendant knowingly causing another to engage in activity by threatening them or placing them in fear. And that was United States versus Boyle, 7th Circuit, 1995. The fear contemplated by Section 2242.1 excludes such fear that a person will be subjected to death or serious bodily injury, but encompasses the use of any kind of threat or other fear-inducing coercion to overcome the victim's will. And that's Cates versus United States, 7th Circuit in 2018. So the record fails to reflect any evidence whatsoever that Kelly used fear or threats to coerce Roshana into prohibited conduct. The government never claimed as much at trial. In a highly instructive case, United States versus Law, which was heard in the 7th Circuit just in 2021, a jury convicted the defendant, Rita Law, of trafficking and forced labor. Law owned and operated 3 massage spas that offered services to its customers. Services that wasn't really on the menu, okay? Y'all know I'm leaving certain words out, right? And so it says 2 of Law's employees, HV and XC, who were born in Vietnam and China, respectively, and traveled to work for Law at her massage spas. They spoke no English and had no support systems in the United States. The evidence at trial revealed that once at the spa, Law forced HV to provide services to customers by claiming that HV's husband owed her a debt that HV had to work at the spa to pay off Law. Law bullied XC into providing services and demanded money for room and board. HV and XC were pressured into working at the spas under brutal conditions, were not permitted to leave the spas unaccompanied, were denied hourly wages and adequate food. Law confiscated HV and XC's passports and threatened to have them arrested if they did comply. I think it meant did not comply with her demands to provide these particular services. And guys, use your imagination, okay? Law also physically intimidated the women. On one occasion, when HV called Law and told her she was experiencing severe bleeding and feared a miscarriage, Law did nothing and forced her back to work at the spa the following afternoon. On appeal from her trafficking and forced labor convictions, Law challenged inter alia the district court's application of Section 2A3.1 of the sentencing guidelines, as defendant does here, challenging the quote-unquote fear element of a Section 2242 violations. The Seventh Circuit affirmed, finding that Law had placed HV and XC in fear in a number of ways, including threatening to have them arrested, threatening them financially, and threatening them physically. In contrast, the record is devoid of any evidence whatsoever that Kelly ever threatened Rishona or placed Rishona in fear of any type of harm. At no point during her days of testimony did Rishona testify that Kelly made her feel fearful, and that was the reason she engaged in prohibited sex with him. Indeed, the government's entire theory, as kicked off by Dr. Turner's testimony, was that Kelly groomed Rishona, manipulated her, and induced her into prohibited conduct through a number of ways, but there is simply no evidence that threats or fear was a tactic utilized by Kelly. And for those of you who are new to this channel, Rishona Landfair's testimony lasted a really long time. I think it took me 5 videos to get through her entire testimony. So if you want to go back to August of last year, just go to my community page, click on videos, and then scroll down. And you don't have to scroll that far because it was shortly after Rishona's testimony that I took a break. And I didn't do any videos for like 5 months, so they should be like in the first 2 or 3 rows. You should see Rishona's testimony. So it goes on to say, Rishona testified about how the relationship first turned physical. And then it has a quote from her testimony that says, "So we were sitting in the office area of the studio on the couch, talking, watching TV. And obviously we had began having phone conversations about doing the do. And this particular time it became more physical with touch of the boobs and him rubbing on my private area." Rishona explained that the contact eventually escalated. And then part of this, she did include Rishona's testimony, but you guys don't have to read the testimony because I've already read it. And like I said, it took 5 videos to get through it. So when asked why she engaged in this particular talk with Kelly, Rishona responded, "I just kind of went with the flow." She said he was an adult and that she looked up to him. So again, I went with the flow. Although at one point in her testimony, Rishona testified that she participated in the prohibited conduct because of quote-unquote intimidation, she immediately explained that Kelly was an adult and that she looked up to him. She called herself a passive person and stated, quote, "I just kind of went along with things and then it somewhat became normal," end quote. Rishona did not say she feared Kelly or that he said or did anything to instill any type of fear in her that caused her to have contact with him. When asked to elaborate why she had relations with Kelly, Rishona testified, quote, I started having feelings for him. I was attracted to him in that way, and things were happening so frequently, it was kind of just like being done out of repetition. She also testified, quote unquote, I developed feelings for him and I felt good about our interactions, that he loved me, that he would take care of me, that he was my protector. Child, Rashona repeatedly stated that Kelly made her feel good. So although the government may have plenty to say about Kelly's tactics in inducing Rashona into a relationship when she was underage, the use of threats or fear was not why Rashona engaged in the do with Kelly during the first 5 years of their decade-long relationship. Child, Rashona testified that the relationship turned darker after Mr. Kelly was acquitted in 2008. When asked how the relationship changed when Rashona testified, quote unquote, it changed after the trial was complete. It changed for the worse as far as other women being involved, as far as abuse coming into play and things of that nature. Rashona was 23 or 24 years old at the time Kelly was acquitted and when the relationship allegedly, quote unquote, changed. A fair and honest review of Rashona's testimony leads to the inescapable conclusion that the applicable cross-reference provisions in Section 2G1.13, because Kelly's conduct as described by Rashona arguably satisfies the elements of Title 18 United States Code Section 2243A, not Title 18 United States Code Sections 2242 or 2241. Section 2243A, abuse of a minor, occurs when a defendant, quote unquote, knowingly engaged in an act with another person who had attained the age of 12 but was not attained the age of 16 and is at least 4 years younger than the person so engaging. So that's what Section 2243A states. So to find the defendant guilty of the inducement count, the jury had to conclude that defendant violated the Illinois aggravated criminal abuse statute, which generally incorporates in different subsections, sections 2241, 2242, and 2243. The government's proposed jury instruction only included a theory related to statutory, and did not ask the jury to consider whether defendant used threats or force. The jury was instructed that to find that defendant guilty of the inducement counts, it had to find beyond a reasonable doubt that a person commits aggravated criminal abuse if that person commits an act of it gets a little explicit in here, y'all, so I can't really go into it, but basically saying that the person is at least 13 but under 17, and the person is at least 5 years older than the alleged victim. So this language is akin to the elements of Section 2243A, not Sections 2241 or 2242. A person is capable of committing aggravated criminal abuse under Illinois law by using threats of force, but the evidence was so lacking, the government did not even bother to offer this instruction to the jury as an alternative means of finding a violation of the statute. So the record speaks for itself. Rashona did not testify that Kelly used threats of any kind or did or said anything that created a fear that compelled her to engage in prohibited behavior. Quite the opposite. Rashona described Kelly as showing her affection and love that caused her to participate in the prohibited conduct. That Rashona testified that the defendant later engaged in some abusive behavior after he was acquitted in 2008 is irrelevant to whether he used threats or fear to gain her compliance with the prohibited behavior. Accordingly, There is no evidentiary basis to support application of the cross-reference to Section 2G1.1C2. The most applicable cross-reference is Sections 2G1.1C3 and 2A3.2, which means that the adjusted offense level for this inducement count is 15. So she goes on to say 3, count 10, inducement count as to Mya, base offense level 15, adjusted base level 15. As was the case with count 9, the base offense level for this count is 15 pursuant to section 2G1C3 and 2A3.2 as argued supra. The record is devoid of any evidence that defendant used force threats or force threats of any kind or fear tactics to engage Mya in the prohibited contact at his studio when she was 15 or 16 in the summer of 1996. Mya testified unequivocally that she met Kelly in a mall in Atlanta when she was 15 and he invited her to a concert in Minneapolis. Mya explained that she was attracted to Kelly and had romantic feelings for him. She stated she spoke to him numerous times by telephone and she quote unquote felt very good when she spoke to him and she looked forward to seeing him. Mya testified that she traveled to Minnesota for the concert and called Kelly when she arrived. She attended the concert but only saw him the following morning when he came to her hotel room. Mya testified that Kelly kissed her, touched her boobs, kissed her boobs, and then masturbated. Child. Kelly told her that he wanted her to come to Chicago and she accepted the invitation. Kelly did not follow up on the invitation and did not book any arrangements for Mya to come to Chicago. However, Mya made her own arrangements and went to stay with family in Chicago that summer unbeknownst to Kelly. Mya called Kelly and he invited her to his studio but made no arrangements for her to get there. Child. Mya convinced her cousins to take her to the studio. Mya arrived at the studio with her cousins and Kelly showed them around and took them to a waiting area where they could see him record. Mya and her cousins stayed most of the evening, but Kelly was recording and was not hanging out with Mya and her cousins for most of the evening. At some point, Mya was told Kelly wanted to talk to her in the hallway and Mya went into the hallway to see Kelly. Mya testified, quote unquote, he greeted me with a hug, with a kiss, and held on to her for a moment, and they, quote unquote, kind of made out a little. Mya elaborated, quote unquote, I remember his hand being around my waist, on my bottom, my butt, and then he motioned his hands into my pants as we kissed. And he fondled my chest, and he, kissed. We just kind of made out within the time frame that we were in the hallway. Mya also stated, he touched my vajayjay and he caressed my bottom, my behind. Mya testified that before she left, she had a similar encounter with Kelly. She stated they, quote unquote, embraced, hugged. He held on to me, held my bottom and things of that nature. But it wasn't as long as on the first. It was more like, kind of like a goodbye. See you later. Mya never saw or spoke to Kelly again. But in 2002, Mya sued Kelly and the case settled for $500,000. Y'all, child. Whew. This man obviously had no type of legal representation, management, or nothing if they was just handing out his money. Sony had them handing out this man money left and right, which is the time that they should have been addressing this stuff and confronting and finding out if it was true or not, instead of just paying these people off. And now here we are decades later with the Me Too people, and they just bringing this stuff and like, oh, he paid her off, so he must be guilty. But anyway, it says there is not a single word in Mya's testimony from which any jury or any judge under any standard of proof could find or infer that Kelly used threats or fear tactics to engage Mya in prohibited contact. Mya was extremely forthcoming when she testified that she approached Kelly for an autograph in Atlanta and that they spoke on the phone, and she was excited when he invited her to Minnesota to see a concert. So excited that she bought him a red rose on the way there. As to the charged offense in Chicago, Mya admitted that she went to Chicago to see him and contacted him, not the other way around. There was a quick encounter in the hallway at his studio where he fondled her. They embraced and kissed, and Kelly touched her vajayjay. Mya was hurt and upset when Kelly did not return her phone calls after that encounter. The government cannot point to testimony whatsoever that suggests that defendant committed an act of abuse pursuant to Title 18, United States Code Section 2241 or 2242. The applicable statute in this case is Section 2243, which is incorporated into the Illinois criminal abuse statute on which the jury was instructed. As such, the applicable cross-reference is Sections 2G1.1, C3, and 2A3.2, and she's referring to the sentencing guidelines, which means that the adjusted offense level for this inducement count is 15. So then we move over to number 4. It says count 12, inducement count as to Pauline, base offense level 15, adjusted offense level 15. As with the prior inducement counts, the base offense level for this count is 15, and then she gives the same sentencing guidelines, the sections 2G1.1C3 and 2A3.2. Pauline's testimony is devoid of any claim that the defendant threatened her physically or otherwise or instilled fear in her to gain her compliance in prohibited conduct. Pauline testified that after she discovered Kelly and Rishona engaged in conduct, she began engaging in conduct with Kelly and Rishona. Pauline considered Kelly her boyfriend and stated she loved him. When asked the objectionable question of why she was testifying, Pauline testified that she takes responsibility for having sex with Kelly and that she probably could have just said no, but she loved him. Exhibit D, Pauline's testimony at R2317. Pauline offered that she still loves him and that he was like, quote unquote, best friend meets boyfriend meets dad, all in one person. And they want this man to spend the rest of his life in prison for this foolishness. Now, come on, let's be for real. Now, I can see if he was snatching people, Child, let me tell y'all something. That New York case, remember the chick from Miami? Oh my God, her name began with an A. Oh, Addie. I think she went by Addie. But remember her testimony. Remember she said she had went to the concert and they were at the meet and greet, and he told everybody to leave the meet and greet, and then he did whatever he did. Now her story and that of that doggone Sonia, who they did not believe and found not guilty, they were the only two people that testified that they were forced to do something. And then the Addie chick, she wasn't even one of the victims. She was like a bad acts witness. So that just let you know that these cases are so full of crap. But this is what the U.S. government is doing these days. So let's move on. So while the government's argument that Kelly groomed Rishona and Pauline and induced and exploited them in manipulative ways is fair game, the government cannot, however, convert this testimony into a claim that he used threats or fear to compel the prohibited behavior with Pauline or any other individual. In addition to the testimony itself, this court should look at the government's closing argument. The government never once argued that Kelly used any types of threats or fear to compel the prohibited activity. There is no evidentiary support for the government and probation's claim that Kelly used threats or fear to gain Rishona, Pauline, and Nia's compliance. As such, an offense level of 27, adjusted offense level of 29 for the inducement counts is not permissible. Tell them, girl. So C, grouping. Defendant concedes that the production of CP is not a groupable offense pursuant to the sentencing guidelines, section 3D1. .1, notwithstanding that the accounts all involve the same individual. D, and I would have to see the sentencing report to see what they're talking about. I guess I could bring up the sentencing guidelines to see what they say. But it sounds like what they did was they grouped the charges together in order to come up with a larger sentence. So, for example, say a person is charged 5 times with something that has a sentence of 2 years. So they would get the 2 years on each one of the sentences, but if it ran concurrent, the person would only serve 2 years. However, if it was run consecutively, then the 2 years would turn into 10 years and the person would have to serve a total of 10 years. That's what I'm thinking she's talking about when she's saying that there's not a groupable offense. So D, criminal history category. Defendant and the government agreed that Kelly's criminal history category is 2. Probation contends that Kelly's criminal history category is 3 because an unidentified internet source reveals that he pled no contest and received unsupervised probation in 1997 in connection with a simple battery charge. Probation admits that it has been unable to obtain any court records that reflect Kelly's plea of no contest, his sentence, or proof of how the case was resolved. Instead, it relies on an unsourced internet article containing information that was allegedly obtained from pleadings in a related civil case. Probation is out of control, okay? Probation cannot even identify the internet article on which it relies. Critically, Mr. Alper, A-L-P-E-R, who prepared the probation sentencing report, contacted. Okay, why is this thing not letting me? It's jumping down pages. Okay, hold on, because I'm missing a sentence somewhere. Okay, let's try this again. Probation cannot even identify the internet article on which it relies. Critically, Mr. Alper, who prepared the PSR, contacted undersigned counsel earlier this week and conceded that a law enforcement representative from Louisiana informed him that the arrest and disposition from the 1996 Louisiana arrest was expunged, but Mr. Alper has yet to amend the PSR to reflect that Kelly should not receive a criminal history point from this incident, since expunged convictions cannot be counted toward criminal history points. See United States Sentencing Guidelines, section 4A1.2J. And you guys, I give you those codes in case you want to go and pull them up. You can find all of these. Just enter the section, the title, the code, what I'm reading to you. Just enter that in your Google search bar and it will bring it up for you. And you can read exactly what it means. So an unidentified internet source is hardly reliable information on which probation should be relying on to increase Kelly's criminal history category. In applying the guidelines range must be established by the government by a preponderance of reliable evidence. United States versus Moore, which was heard in the 7th Circuit last year, 2022. United States Sentencing Guidelines, Section 6A1.3, comment: the Commission believes that the use of preponderance of the evidence standard is appropriate to meet due process requirements and policy concerns in resolving disputes regarding the application of the guidelines to the facts of the case. The court may consider a relevant information without regard to its admissibility under the rules applicable at trial, provided the information was sufficient or reliability to support its probable accuracy. United States versus Polson, which was a case 7th Circuit in 2002. A district court may consider hearsay evidence in determining a defendant's sentence, but the hearsay evidence must be reliable. Probation can offer no reliable evidence that shows that Kelly pled no contest to a simple battery in 1997 for a sentence of unsupervised probation that was not expunged. Indeed, if the incident happened at all, it seems obvious that it was expunged based on the representations of a law enforcement official in Louisiana and the fact that no documents from the proceedings are available. And then let me go back up here because there was a note at the bottom. It says, demonstrating probation's clear bias against Mr. Kelly, Mr. Alper told undersigned counsel that he was trying to get further information about the expungement with the help of the government. Mr. Alper explained in sum and substance that he couldn't just rely on the hearsay statements of a law enforcement official in Louisiana. That's just not how we do things. Somebody was trying to call me. Where was I at? That's just not how we do things. Okay, only is exactly how probation did it when they hit Kelly with a criminal history point based entirely on an unsourced internet article. Presumably, the hearsay statement of a law enforcement officer is more reliable than an unidentified internet article. Apparently, hearsay is only unreliable to probation when it works to the benefit of Kelly. All right, girls, so let's pick back up. Expungement aside, an unsourced internet article that probation cannot even cite based on some information about a civil case that references a prior criminal case is not reliable evidence. Indeed, this evidence is not mere hearsay. It constitutes 4 or 5 levels of hearsay and lacks foundation since probation does not even identify the mystery quote-unquote internet article that serves as the source of the information. An unknown internet reporter for an unknown online publication obtained information from a civil court proceeding or document that apparently referenced a district criminal proceeding for which there are no available records, and then reported that information in an unknown, unnamed internet article. This information is not sufficiently reliable to raise Kelly's criminal history category. Thus, Kelly's criminal history category is 2. Child, they just pulling at all the stops, okay? So E, combined offense level. The combined offense level is 32. The sentencing guidelines, section 3D1.4 instructs the offense level applicable to the group with the highest offense level is 29, which relates to 1 CP count. Because Kelly was convicted of 2 additional CP counts, which are equally serious, 3 levels are added to the highest offense level of 29 for a total combined offense level of 32. Because the inducement counts have an adjusted offense level of 15, as discussed, they do not increase the offense level. Accordingly, Kelly's guideline range is 135 to 168 months imprisonment. Defendant concedes that he is subject to a statutory minimum sentence of 10 years imprisonment. So what is, let's see, 120, 120 would be 10 years. 32, 11, 44, 12, 56, 13, 6, okay. So 16, what do you look, 15 to 16 years? Is my calculation right, y'all? Y'all let me know in the comments. So the defendant concedes that he's subject to statutory minimum sentence of 10 years imprisonment. Okay, 2. The sentence should run concurrent to Kelly's 30-year Eastern District of New York sentence. Pursuant to the Sentencing Guidelines, Section 5G1.3c, the sentence in this case may be imposed concurrently, partially concurrently, or consecutively to the prior undischarged term of imprisonment to achieve a reasonable punishment for the instant offense. Application Note 4 directs the court to consider the following factors. A. The type, determinate, indeterminate, parolable, and length of the prior dischargeable sentence. B. The time served on the undischarged and the time likely to be served before release. C. The fact that the prior undischarged sentence may have been imposed in state court rather than federal court, or at a different time before the same or different federal court. And D. Any other circumstances relevant to the determination of an appropriate sentence for the instant office. The foregoing factors militate. The foregoing factors militate in favor of a concurrent sentence. Kelly has been sentenced to a 30-year. We got a pop up here. To a 30-year sentence, which, as discussed supra, is tantamount to a life sentence. According to data compiled by the Sentencing Commission, the average life expectancy, she already said, is 64. Kelly is already 56 and has barely begun his sentence. Kelly's health issues do not improve his chance of discharging his Eastern District of New York sentence. Additionally, the sentence was imposed by another federal court rather than a state court. Another relevant circumstance for the court to consider is that Kelly's punishment has been enhanced because the government unnecessarily engaged in piecemeal prosecution of him, presumably with the purpose of increasing his punishment. In fact, Kelly's Northern District prosecution arguably runs afoul of due process and double jeopardy principles, where the offenses charged in this case were covered by the Eastern District of New York's RICO prosecution. Because the government rarely, if ever, prosecutes defendants in separate, simultaneous prosecutions, as the government did here, there is no authority to address whether consecutive sentences would violate due process or double jeopardy prohibitions. Ain't this a mess? However, the Supreme Court decision in Rutledge versus United States, which was a case heard in 1996, is instructive. In Rutledge, the United States Supreme Court had held that narcotics conspiracy is a lesser included offense of a continuing criminal enterprise, and that it is therefore unconstitutional to impose cumulative punishments for both crimes. That means that if one U.S. Attorney's Office prosecuted a defendant for a narcotics conspiracy and another U.S. Attorney's Office simultaneously prosecuted a continuing criminal enterprise that included conduct addressed by the narcotics conspiracy, the sentences would have to run concurrently without violating the double jeopardy clause. Child, Jennifer Bongine be on it, okay? She got some law clerks in her office that be digging deep for this information. So similarly, the specific RICO theory advanced by the Eastern District of New York prosecutors included the conduct alleged in the Northern District indictment. The Eastern District of New York indictment alleged that the purpose of Kelly's so-called enterprise was to, inter alia, abuse individuals and produce CP between the years 1994 and 2018. See Exhibit A, which I don't have here, and it might be at the bottom of this document. The offenses charged in this indictment squarely fall within the alleged purpose. Actually, I think Exhibit E was the Eastern District of New York indictment. Purpose of the RICO enterprise. No logical reason exists for the government's failure to bring the case in a single indictment except to unfairly enhance Kelly's punishment. Even if consecutive sentences would not run afoul of the double jeopardy clause, the sentences should run concurrently as a matter of fairness. The government contends that significant incremental punishment is necessary in this case to account for the fact that this case is different from the New York case in nature and scope. Here, defendant was convicted of abusing minors, and that abuse occurred prior in time to the abuse of adult women and minors in the New York case. Child, government memo at 19. So that was some child they wrote in the paperwork. So the government is simply wrong. The Eastern District of New York indictment speaks for itself. Eastern District, New York charged conduct from the 1990s like that charged in this case, including presenting testimony that Kelly allegedly had a relationship with Aaliyah in 1994. Like the government did here, the prosecution in Eastern District of New York also presented evidence that Kelly recorded conduct with Stephanie in 1999, which constituted exploitation. The scope of the enterprise covered the exact same time period, and the Eastern District of New York prosecutors maintained that creating the videos and having doing the do with the minors was one purpose of the enterprise. Under these circumstances, there was no reason for the government to engage in piecemeal prosecution except to attempt to enhance Kelly's punishment and perhaps give both the U.S. Attorney's Office an opportunity to hold press conference. Girl, you left out the fact that them hookers over there in the Eastern District of New York that started a law firm, honey. That which is what they do, what prosecutors do at the state and federal level. They'll take on a really big case in order to further something else that they're trying to do, like start their own law firm or become a judge, that type of thing. These type of cases look good on their resume and they can use it for promotion. So, under these circumstances and the fact that Kelly is serving a de facto life sentence, this court should exercise its discretion and order the sentence in this case to run concurrent to the Eastern District of New York sentence. 3. Application of Section 3553A. Factors demands a low guidelines range sentence. Section 3553A sets forth various factors that this court must consider in rendering a sentence. A. The nature of the circumstances of the offense. Kelly concedes he has been convicted of serious offenses involving 3 individuals, including 3 counts of producing CP with Rishona. The most serious counts of the indictment relate to Rishona, with whom Kelly had a 12-year romantic relationship and a seemingly genuine friendship until the government indicted Kelly after the airing of Surviving Lives in 2019. Indeed, Rishona would have been happy to put her experience with Kelly behind her until the government revived the case and insisted that she cooperate with the prosecution, including by inducing her to participate with promises of restitution riches. Child, as the government showed, Kelly and Rishona texted regularly with one another, attended each other's birthday celebrations, and frequently socialized, including with Rishona's parents. When Rishona lost her grandmother, Rishona encouraged Kelly to reach out to her mother to give his condolences. Kelly assisted Rishona with financial needs long after any claims of obstruction could be made, and Rishona told Kelly she loved him shortly before he was indicted when she was worried about the impact of Surviving Lies docudrama and had on him. So Rishona admitted from the stand that her relationship with Kelly was close and friendly as of 2019. That Kelly and Rishona maintained a close relationship until he was indicted in 2019 is, of course, not an excuse for the offenses of which Kelly has been convicted and will be sentenced, but to ignore that Kelly and Rishona's illegal and inappropriate relationship that began in 1997 and morphed into a lengthy relationship between adults who remained close friends until Kelly's indictment in 2019 ignores the full nature and circumstances of the offenses for which he was convicted. Importantly, it was not Kelly who placed the tapes into the public domain, which may have caused Rishona as much harm as the acts themselves. That Kelly did not produce CP for any commercial purpose does not relieve him of criminal responsibility. But if Kelly had been responsible for placing the tapes into the public, the government surely would point to that fact as aggravating evidence. It is most certainly relevant that the tape of Rishona and Kelly was stolen by her own aunt and given to the Chicago Sun-Times. To undersigned's knowledge, Rishona's aunt, Stephanie Edwards, also known as Sparkle, was never indicted for trafficking in CP. Child, no, she wasn't. And neither was Lisa Van Allen. I'm just saying. So similarly, as to Pauline, she testified that her relationship with Kelly that started when she was a teenager also morphed into an adult relationship in which she loved Kelly. Indeed, Pauline testified adamantly that Kelly was wrong for taking advantage of her when she was underage, but she acknowledged that she loved him and still loves him. Again, these facts are not relevant as it relates to Kelly's culpability in the crimes charged, but they are important factors when considering the circumstances of the offenses and its impact on the complaining victims. Conduct must be considered on a continuum of seriousness, and Kelly's conduct, while serious, did not involve some of the aggravation that is typical of CP cases and trafficking cases. Finally, the inducement count as to Mya, count 10, is far less serious than the counts related to Rishona or even Pauline. Mya admitted that she sought out Kelly. She moved to Chicago for the summer to see him. She insisted on going to his studio, and during an isolated incident in the hallway, he kissed her, embraced her, and touched her. Mya was either 16 or almost 16. I think she meant was 16 or almost 17. When this occurred, Kelly was 28. This incident did not involve threats, violence, coercion, and occurred primarily because Mya wanted to pursue a romantic and connection with Kelly, as she testified to. Of course, a jury found Kelly of an inducement found Kelly, I think she meant guilty, found him guilty of an inducement offense as to Mya, and he faces punishment for that offense, but it does not mean the circumstances of this offense rise to the seriousness of even the other inducement counts in this case. There is no denying that Kelly's convictions are serious and the harm caused real, but the government's insistence that there is nothing mitigating about Kelly's conduct or life is inconsistent with the actual evidence presented at trial and heard by the jury. B. The history and characteristics of the defendant. Defendant is widely accepted as a musical genius with a rags to riches story. He is considered the greatest living R&B singer and has earned multiple Grammy Awards. He has written and produced music for celebrated artists like Michael Jackson and Whitney Houston. Notwithstanding his legendary status, Robert Kelly is a man with a complicated story that is highly relevant to this court's goal of fashioning an appropriate sentence for him. Defendant has been portrayed by the government and the media as a one-dimensional villain, undeserving of any measure of humanity or dignity. This court is charged with considering defendant's unique history and characteristics and rendering an appropriate sentence. Defendant's history and characteristics reveal that he is not an evil monster but a complex, unquestionably troubled human being who faced overwhelming challenges in childhood that shaped his adult life. This evidence is critical to understanding how and why defendant finds himself in the current situation. In this vein, the court must consider the offenses at issue in this case are 25 years old. Contrary to the government and probation's contentions, Kelly did not engage in a pattern of creating CP after his state court indictment in 2002. While Kelly was not a child in the late 1990s, he also was not the middle-aged man he was at the time of his 2019 indictment. In the mid to late 1990s, the time of the underlying conduct, Kelly was a damaged man, was a damaged man in his late 20s with an extraordinary traumatic childhood that he failed to confront. He lacked the insights or ability to appreciate the ways in which his traumatic childhood impacted his unhealthy sexual development and harmful choices. As acknowledged in the pre-sentencing investigative report, and set out more fully in the extensive reports prepared by Dr. Park Dietz, MD, MPH, PhD, and Dr. Renee Sorrentino, defendant experienced a traumatic childhood involving severe, prolonged childhood abuse, poverty, and violence. His victimization continued into adulthood where, because of his literacy deficiencies, Kelly has been repeatedly defrauded and financially abused, often by people he paid to protect him. And for those of you that haven't been following from the beginning, there is a video that I did about a year and a half ago, of the mitigation report, where I read the mitigation report. And so once again, go to my community page, click on videos, and then just start scrolling down. And I'm usually pretty clear in my titles what I'm talking about, so it should say mitigation report in the title. So before we continue on, let me go back up. There was a note at the bottom of the previous page, and it says, Kelly has attached the mitigation reports that were prepared in connection with his Eastern District of New York sentencing that occurred last June. Kelly, okay guys, so there you go. So it should be around June of last year. It was either the end of May or the beginning of June that I read that mitigation report of 2022 I'm talking about. So once again, you don't have to go back that far because I haven't done any videos between the middle of September and about a week ago. I came back a week ago. So there's 5 months in there that there are no videos. So it should take you there quickly. So the note says, okay, with his Eastern District of New York sentencing that occurred last June, Kelly has redacted those portions of the expert reports that relate solely to the Eastern District of New York case. Kelly was unable to retain the experts to modify or amend the reports, specifically for use in this case due to a lack of resources. Even if Kelly had access to resources, the government has restrained his ability to use any resources for his defense. The reports are relevant to the extent that they speak to Kelly's personal history and characteristics. Okay, so she continues on And she says that Dr. Dietz' report focuses on adverse childhood experiences, illiteracy, and Kelly's positive traits. Incorporated by Dr. Dietz' reports are findings of Dr. Daniel Martell, PhD, who conducted neuropsychological testing of the defendant. Dr. Sorrentino's report contains a complete history of Kelly and focuses on Kelly's sexual history, including a detailed discussion of the abuse he suffered as a child. Interviews in connection with these reports. The reports are lengthy, and defendant will not quote from them extensively, but will highlight certain portions. Critical to understanding the history and characteristics of the defendant. Of the defendant is understanding the traumatic childhood that shaped him, as Dr. Dietz writes. Traumatic childhood events such as abuse, neglect, and witnessing experiences like crime, parental conflict, mental illness, and substance abuse can result in long-term negative effects on learning, behavior, and health, often referred to as adverse childhood experiences or ACEs. These types of events create dangerous levels of stress that can derail healthy brain development and increase risk of smoking, alcoholism, depression, heart disease, and dozens of other illnesses and unhealthy behaviors throughout life. Dr. Dietz opines that Kelly endorses a significantly high number of adverse childhood experiences that cannot be overlooked when considering his history and characteristics. Dr. Dietz writes, many of Mr. Kelly's problems are now known to be adverse outcomes associated with cumulative ACEs, including but not limited to below average academic and literacy skills by kindergarten age, lower school engagement, learning behavior problems, not completing high school, STDs, having 50 or more sexual... Wait a minute. I hate when this thing starts skipping all over the place. Hold on, y'all. Okay, child. Where was we at? Okay, 50 or more sexually... sexual partners, 50 or more partners, anxiety, panic disorder, and criminal conviction. Separately, in criminal conviction, meaning the Eastern District of New York case. Separately, there is now substantial evidence that a history of being abused as a child is associated with subsequent conviction of sex offenses. As set forth in detail in Dr. Dietz's report, Kelly grew up in poverty and experienced a chaotic home life. One of his longtime employees and friends aptly writes in a letter of support, Robert was born in poverty, but even as a child, he had a passion for music. He shared with me some of the abusive circumstances he grew up in. It was a horrible environment for any child, and Robert is amazingly resilient to have even survived it. As a young adult, he was homeless and earning money as a street performer on the frigid streets of Chicago. Eventually, his hard work and talent earned him a record deal, but that deal wouldn't take away his illiteracy or the traumatic experiences he endured. And that was part of a letter from Diane Copeland. And you guys, let me know if you want me to read the letters in another video. Let me know in the comments, not in the comments as this the live chat as this video is playing, but in the comments below whether or not you want me to read the character letters, because it combined new letters for the Chicago case and then also letters from the New York case, and I can do a video reading those. Kelly never knew his father and was raised by his mother and stepfather, who by all accounts were heavy drinkers and would sometimes violently fight. During one vivid fight, defendant's stepfather pushed his mother and her dress got stuck in a car door before defendant's stepfather drove off, dragging his mother for a short while her sons threw bricks at his car. By objective accounts, Kelly and his two brothers suffered physical abuse at the hands of their mother, who disciplined them with whippings, with cords, and switches. On one occasion, Kelly's mother grabbed a knife to threaten Kelly and his brothers and accidentally stabbed Kelly in the left arm. Lord. Neither Kelly nor his brothers considered the punishments meted out by his mother as abusive. Indeed, Kelly's mother was beloved by her children. Kelly lived in a violent neighborhood with significant gang and drug activity. Kelly steered clear of gang and drug possessions, but still witnessed significant violence that made lasting impacts on his life. For example, at the age of 14, Kelly was shot in the arm with a .22 round while riding his bike down the block. Critically, Kelly experienced multiple sources of childhood abuse and premature sexualization and shed significant light on some of his behaviors. Dr. Sorrentino and Dr. Dietz write at length about how Kelly was abused as a child for many years by his older sister. Both of Kelly's brothers report being abused by their sister. Defendant also was abused by a landlord and family friend known as Mr. Henry. I wonder if Mr. Henry's still alive, y'all, and what he think about all of this. Mr. Henry, if you out there, we need to talk to you. So when Kelly was only 6 or 7 years old, his sister started bothering him. The abuse included oral and penetration and persisted into middle school. Kelly's sister began dating their first cousin, Lewis, and where is Teresa still out there, y'all? We never did get Teresa to unearth herself throughout both of these trials. You would think she would have came in and tried to help her brother, since all this is public knowledge at this point. But no, she just somewhere hiding, child. I don't even know how she can live with herself knowing that her behavior and what she did to him is a direct result of why he's in the situation that he's in now. But anyway, child, it goes on to say that Teresa began dating their first cousin, Lewis, and she would have Kelly take Polaroid photos of them doing their do. And Mr. Henry abused Kelly on a weekly basis during the same general period of time. The abuse included oral and anal. Oh my God, Lord have mercy. This is crazy. So Dr. Sorrentino opines that defendant's history of childhood abuse should be considered a mitigating factor in his sentencing hearing. It is my opinion, with reasonable medical certainty, that Mr. Kelly's history of childhood abuse is consistent with the definition of mitigating factors as any fact or circumstance that lessen the severity or culpability of the criminal act. The following evidence supports this opinion. 1. Mr. Kelly's history of childhood abuse represents a hardship or circumstance that was out of his control. And 2, this history has been described in scientific literature as contributing to adult hypersexual behaviors. 3. Mr. Kelly's adult hypersexual behaviors were factors in his criminal conviction. Defendant convictions. A defendant suffered other childhood trauma, including witnessing the drowning death of his first childhood girlfriend, Lulu, when they were 8 or 9 years old. Defendant and Lulu. Okay, wait a second. Okay, defendant did not, because for some reason it won't take me back to the top of the page, but you guys have heard the story. The defendant did not know how to swim and began screaming as he watched his friend drown. Multiple sources confirmed this traumatic event and opined that it had a significant impact on Kelly. And I also think that what happened with the girl, and her real name isn't Lulu, but the family was found and interviewed. You know, they don't really want to discuss, but did confirm that this story is true. and I can't remember what her real name is, so I do apologize for that. But I think that this plays a part in why he deals with people like the Azrael Claries, the Jocelyn Savages, like wants to take these young women under his wing and provide for them. And even though he has the abusive side of him, but also, and not, I shouldn't say, well, abusive according to the courts, right? Whether they were willing participants or not willing participants, we done had that discussion 100 times. Not going there, but I think that that is what motivates him. The whole having the house with all of them in it, living together. I think subconsciously that is sort of, I couldn't protect Lulu, but I can protect these other women. And you guys know Lisa Van Allen with her crazy self. She was part of a trafficking situation. So she was able to, and I really believe that the guy, and once again, can't remember his name, but if you find the video that I did about Tony Rivera, she names the person. And actually, the Tony Rivera story was actually documented on TV1 about how she got involved in trafficking, and that's how she met Lisa Van Allen. But in any event, regardless of how horrible some of these people were and vindictive and trying to come after him, stealing from him and taking advantage of him, even at the age of 18 and 19 years old, he still had this urge to protect them, to protect Jocelyn from her parents, protect Azrael from her parents, trying to sell, using her as their tool to make money is basically what it came down to. And I think all of that derives from what happened with Lulu. So let's see, where were we at? Okay, so Kelly is functionally illiterate. Kelly's inability to read and write as a child was a significant source of shame, embarrassment that persists to this day. He was bullied as a child because he could not read or write and eventually dropped out of high school after being held back several times. Kelly spoke of the shame and fear he experienced later in life when accepting Grammy Awards since he could not read the teleprompter. At the time of the underlying offenses, Kelly functioned and still does to some degree as a much younger person than he actually was. Even Lisa Van Allen testified that she and Kelly connected because they shared the same interests despite their significant age difference. Kelly's intellectual disabilities shed some light on why he engaged in inappropriate relationships. Dr. Dan Martell re-examined Kelly and reported that he had significant impairments in all areas of academic functioning, placing him in the bottom first to third percentiles and at the early elementary school level, i.e. first to third grade overall. Dr. Martell's testing indicated that Mr. Kelly's cognitive abilities are not even developed, such that his full-scale IQ, which fell in the borderline range, F full-scale IQ equals 79, and y'all know that a 75 was the plateau, that was the level where people, years ago were considered, they don't use the term mentally retarded today, but where they consider a person developmentally delayed. But these are the kids that were in the special classes at school that never received a high school diploma, but were just kept in these classes for the 12 years and then given a certificate of completion. Or they could have been sent off to special schools that only dealt with special needs kids, right? So that's scary. And the fact that he turned out to be such a prolific musical genius. Defendants' literacy deficiencies have led to chronic victimization in adulthood. Defendant has been financially exploited his entire adult life. At one point in his career, he was told he was worth $900 million. He is now destitute. Now, I have to disagree with that, Jennifer. And you up there talking about the guy who wrote the sentencing report, reporting on stuff that had been documented or factual, that him being worth $900 million, we know is not factual like his album. He may have made Sony $900 million, but as far as money that he actually received and held in his hand, at most has been, people have studied this, guys. At most, he has received, and that's the only amount that you can really account for. He has received at the most $300 million, but most likely $150 million, I believe, is the number. But the range is $150 million to $300 million is the most that his personal net worth has ever been. And let's see. Here we go. Jumping. I cannot get to this page, y'all. Okay, Dr. Dietz also details a number of positive attributes of the defendant as reported by the collateral sources. Defendant is by all accounts a generous and forgiving person. Defendant has employed his family and friends and continually re-employed them after they stole from him. One of the defendant's friends recounts, "He really has a good heart. He's not a bad person. He has a real forgiving heart, you know. People that did things to him, people around him that sued him and came back, and he forgave them and gave them their jobs back. And he's real. He's a real kind-hearted person." Another friend described defendant as follows: "He is compassionate and empathetic. When Robert learned of a shooting that took place that claimed many lives and devastated a small community in Virginia, he stopped what he was doing and wrote a song called Rise Up, which to this day is still played, and every penny of the proceeds is shared by the families, the college, and the community." And that was from Alicia Evans, who I believe is Lily. Don't quote me. Don't quote me. And then once again, if you guys want me to read all the letters in another video, I'll be more than happy to do that. So another time I recall worth honorable mention was when Robert saw on the news that a horrific incident had taken place at the E2 nightclub in his hometown. There had been a stampede where 21 people were trampled to death. Robert gave 21 families whom he did not know money towards funeral expenses. Defendant is also described as down to earth and someone who eschewed the celebrity life, more comfortable keeping close to the community of his childhood. Reports from Dr. Dietz and Dr. Sorrento and supporting letters provide additional and significant evidence of defendant's history and characteristics. C. The sentence must be sufficient but not greater than necessary to satisfy the sentencing goals. The court shall impose a sentence sufficient but not greater than necessary to comply with the purpose of sentencing, to set out below. Reflect seriousness of the offense, promote respect for the law, and to provide just punishment for the offense. And once again, a sentence at the lower end of the guidelines range reflect the seriousness of the offense, promote respect for the law, and provide just punishment. Kelly already discussed at length the nature and circumstances of the offenses. At bottom, Kelly engaged in prohibited relationships with Rashona and Pauline starting in the late 1990s. Unfortunately, Kelly was not the first or the last man to engage in a prohibited relationship with a teen. Frankly, most men who engaged in prohibited relationships in the 1990s and before have never paid any consequence for their actions, let alone facing a sentence of life in prison. Any sentence or imprisonment for 25-year-old conduct reflects the seriousness of the offense and will promote respect for law in light of the government's apathy towards such crimes prior to the Me Too movement. Moreover, Kelly is already serving a de facto life sentence for conduct like that charged here. Any sentence of imprisonment promotes the respect for law where Kelly is likely to die in prison no matter what this court sentences, I hate that she keeps saying that, sentences him to in this case. Two, to afford adequate deterrence. At the outset, Kelly's 30-year sentence in connection with his Eastern District of New York already solves any specific deterrence consideration since Kelly is unlikely to survive prison. Defendant is serving a de facto life sentence in connection with his Eastern District of New York case, while the life expectancy of general prison population is 64 years. She said this over and over and over. We're not reading this again. Okay, so let's scroll down. Okay, did we read the names? Okay, we are gonna read this, okay? So let's see. Is Dr. Dietz and Sorrento confirmed defendant is not a pedo, which is diagnosis that Kelly has never received. Dr. Sorrento opined, I consider the diagnosis of the P word, given Mr. Kelly's alleged history of contact with individuals of a certain age. The diagnosis of that is used to refer to individuals who experience recurrent, intense, fantasies or urges involving activity with people 13 or younger. I reject this diagnosis because Mr. Kelly does not report a history of arousal or prepubescent individual, and his behavior has never involved those type of individuals, and you guys know I had to skip all around that. In sum, no sentence is necessary to specifically deter Kelly, since he is already likely to spend the rest of his life incarcerated. Whatever sentence this court imposes on Kelly, whether it is 10 years imprisonment or something greater than 10 years, the sentence will afford little deterrence to the general public, because the general public has no reason to believe that they would be targeted for prosecution and enhanced punishment as Kelly has. The following iconic music artists, Bob Dylan, Elvis Presley, Jerry Lee Lewis, David Bowie, Jimmy Page, Bill Wyman, Ted Nugent, Steven Tyler, Mick Jagger, Iggy Pop, and Marilyn Manson have all been accused of abusing underage individuals. None have been prosecuted and none will die in prison. The government has shown a unique appetite in prosecuting and punishment for Kelly as compared to his white counterparts. Now, child, she telling it like it is now. She ain't lie. Let's see. Counterparts. Thus, it is unlikely that Kelly's sentence will have any deterrent effect on the general public. It surely will have no additional deterrent effect than does Kelly's existing 30-year sentence. The general assumption is that the government would not prosecute anyone but Kelly as harshly for similar conduct. To have a deterrent value, the general public has to conclude that they too could face the consequences that Kelly faced if they engaged in similar conduct. The government's failure to focus its attention on other artists and musicians with similar backgrounds to Kelly fails to leave the general public with that impression. 3. To protect the public from further crimes of the defendant, whatever sentence this court imposes will do nothing to protect the public, since Kelly has already been incapacitated by a sentence that is the functional equivalent of life given his age. He's already addressed the sentencing consideration in the preceding section in connection with discussion. 4. To provide defendant with needed treatment. As stated already, Kelly is already sentenced to a term. Okay, child. His sentence affords plenty of opportunity for Kelly to obtain treatment in prison, with which he would comply, but he has little to no chance. Okay. Unpaying in similar contact. The government failed to focus its attention. Similar background. Okay. As stated, Kelly already sentenced to a term. His sentence, a concurrent sentence at the lower level, and I'm sorry guys, because it's for some reason my page in Adobe is not scrolling. It's jumping when it's time to go to another page. So I have to go back and find where I was at. As stated, it's to provide defendant with needed treatment. A concurrent sentence at the lower end guidelines range will unlikely change Kelly's fate, but it leaves a sliver of hope that Kelly may survive prison and have the chance to die outside prison walls. That is the best Kelly can hope for, absent reversal of the Eastern District of New York conviction. Section 3553A factors, and specifically the mitigation presented to this court, demands that Kelly be afforded that tiny chance of leaving prison someday when he's far too old to be any risk of harm to anyone. Okay, so she was talking about treatment. His sentence affords plenty of opportunity for him to get treatment, which he would comply. Okay. And then I think that was it. So what do you guys think about this? I agree that so she says, for the foregoing reasons, defendant's sentencing range is 135 to 168 months of imprisonment. A concurrent sentence at the lower end of the guideline range is sufficient, but not more than necessary to satisfy the sentence goals. Respectfully submitted, Jennifer Bunjing. So what do you guys think about that? Okay, so now this video, let me know in the comments, but this video here is already at an hour and 44 minutes. I am going to take it to 2 hours if I can, because there were a couple of more documents. Let's see which ones I want to read in this. This was the sentencing memorandum. Then we had Rashona's testimony, which I've already read the testimony. We had the character letters, which I'll only read if you guys want me to read them. Then we had the government requesting a delay to talk about the restitution. The nerve of them. Okay, so let's read what that says. So they said, United States of America by John R. Louch, United States Attorney for the Northern District of Illinois, moves pursuant to Title 18, Section 3664 D5 to defer the calculation of restitution in this matter until approximately 30 days after sentencing. The nerve. Okay? So, according to John Louch, he says on September 14th, Mr. Kelly was found guilty on the charges relating to Rashona, Pauline, and Nia. He says the three individuals are entitled to restitution, assuming the government is able to demonstrate by a preponderance of the evidence that they suffered losses that were approximately caused by Kelly. Them heifers ain't suffer no losses. The government has produced some material that allegedly supports the victim's claims of restitution through probation. Defendant intends to file a supplemental sentencing memorandum addressing the government's restitution request by tomorrow. Failing to show any good cause, the government now requests an extension. They say that this case was originally set for trial to commence September 13, 2021. Billing records of Rashona's personal counsel attached as exhibit to defendant's most recently filed Rule 33 motion, which he denied. I told you guys when I was reading that motion, he was going to deny it. Showed that the government was discussing restitution with Rashona and presumably all the individuals as of April 2020, nearly 3 years ago. Indeed, restitution seems to have been a strong motivator in gaining the victim witnesses' cooperation in the case. Dang, so y'all admitting it. Trial was adjourned a number of times while Kelly was being tried in the Eastern District of New York. The trial was rescheduled to commence on August 1st, 2022. Undersigned counsel filed her appearance in the case February 18, 2022. Despite that, undersigned counsel had a 4-week jury trial in Los Angeles that commenced at the end of May and did not conclude until June 21st, and also had a simultaneously prepared post-trial motions and sentencing memorandum for Mr. Kelly's sentencing hearing in the Eastern District of New York that occurred on June 29th. She was denied a 90-day continuance to prepare for this trial. Under extremely difficult circumstances, undersigned counsel nonetheless timely filed pretrial motions in this case while on trial in Los Angeles and was ready for trial in this case that ultimately commenced on August 15. Meanwhile, the government had years to compile its restitution. Okay, wait a minute. This might be, hold on a second. I thought this was the John Louch one. Oh, this is him objecting. I'm sorry, guys. This is R. Kelly objecting to them having the unmitigated gall to be asking for more time. So I do apologize. Okay. Let's see. Meanwhile, the government had years to compile its restitution evidence, including 5 months since a jury returned a verdict of guilty. If undersigned counsel, without the incredible resources of the United States government, could get trial ready for this case in less than 6 months, while also trying another lengthy, high-profile case across the country, and prepare for a complex RICO sentencing hearing on the other side of the country, the 4-person U.S. Attorney's team, with the resources of its office, surely should be ready to move forward with restitution at the upcoming sentencing hearing. 13. Critically, prior to trial in this case, undersigned counsel and the government had extensive conversations about the possibility of resolving this case in a manner that did not involve going to trial. Due to the government's unreasonableness on counts they lost anyway, defendant proceeded to trial. And see, y'all, I told y'all these people never offered this man no plea deal. Okay, during those conversations, the government emphasized that restitution for the victims was a non-negotiable aspect of any plea agreement. Defendant mentions this only to underscore that the government has been focused on restitution for a very long time and should be ready to proceed with all aspects of sentencing, including restitution. The government's motion failed to show good cause for its request to defer restitution. The 3 victims, one of whom has already received $500,000 in a civil lawsuit from Kelly, have had years to compile whatever information they believe is relevant to demonstrating the full amount of their losses. Another 30 days cannot possibly be necessary. If restitution is deferred, it almost certainly will result in Kelly being absent for his restitution hearing. Indeed, the district court judge in the Eastern District permitted the government to defer restitution, which resulted in Kelly having to appear by way of Zoom. Kelly reported that he could not hear or understand what was taking place during that restitution hearing. Given Mr. Kelly's learning disability, he needs to be present. If restitution is deferred, he likely will already be designated to another BOP and will have to appear remotely, to which defendant does not consent. Furthermore, traveling back and forth from whatever facility he may be at to attend a restitution hearing is disruptive and unreasonable waste of resources. Deferring restitution also results in piecemeal appellate litigation. Defendant will be forced to file 2 separate notices of appeal, which is simply unreasonable and unnecessary. The government should be ready for restitution. They have shown no hardship or reason why they cannot be. If the government concedes that an evidentiary hearing for restitution is required, it should disclose that to the court, and the entire sentencing hearing should be adjourned, not just the restitution piece. Accordingly, this court should deny the government's request to defer a calculation of restitution to, or adjourn the entire sentencing hearing, because the government's restitution request will require a full-blown evidentiary hearing to be discussed in Kelly's restitution memorandum. All right, so that was from Miss Jennifer Bongine. Let me see what else I got out here. Okay, let's see. Okay, so this is what I started reading, you guys. Okay, so this was what the government had to say. So the government, and this is what Jennifer Bongine was responding to. I accidentally opened the wrong file. So the government's motion to defer calculation, the United States under John R. Lausch Jr. Oh, child, let's skip down here, all them formalities. On September 4th, 2022, a jury found the defendant guilty on 6 counts of a superseding indictment to include, he names the counts, in light of defendant's convictions pursuant to USC Code 2259, 2429, and 3663A. The court must order restitution to the victims of these offenses in an amount determined by the court. 3. Defendant's sentencing hearing is scheduled to proceed on February 23rd. 4. On January 24th, 2023, the government submitted a victim import spreadsheet to the U.S. Department of Probation. On February 3rd, 2023, the government submitted a supplemental version of the offense regarding restitution to probation. As set forth in the supplement, the government has received some information related to the restitution amounts. However, the government is in the process of obtaining additional information. 5. If the victim's losses are not ascertainable by the date, that is 10 days prior to sentencing, the attorney for the government shall so inform the court, and the court shall set a date for the final determination of the victim's loss not to exceed 90 days after sentencing. And that is Title 18 United States Code 3664D5. 6. As the Supreme Court has stated, the procedural provisions of the Mandatory Victims Restitution Act reinforce the substantive purpose of the Act, namely that the statute seeks primarily to ensure that victims of a crime receive full restitution. Dolan versus United States, and that was a case heard in 2010. 7. Because the amounts of the victim's request for restitution has not yet been finalized, the government requests additional time beyond the February 23rd sentencing hearing to allow for the victim's loss to be fully ascertained. The government has conferred with defense counsel, who objects to this motion. Wherefore, the United States respectfully requests that the court grant this motion pursuant to 3664D5 and defer the calculation of restitution in this matter until approximately 30 days after sentencing to allow time for the victim's losses to be fully ascertained. Okay, first of all, Rashona Landfair lived off of Mr. Kelly for 12 years. So she don't need no restitution. She lived a good life. He paid for her to go to college. You know, he helped her family with their businesses. You know, he provided for her. You know, regardless of the circumstances, she has benefited and does not deserve any restitution. Nia sued him and somebody gave her $500,000. And then Pauline, you know, she with the shits and giggles, okay? So she obviously has not been harmed by this situation, but, you know, toss her a few dollars. Well, this is what the judge had to say, y'all. The judge said very succinctly, okay, he said, the government's motion to defer the calculation of restitution is denied. Okay, it's denied. The court will consider restitution at defendant Kelly's sentencing hearing. The court notes that the possibility of restitution is slim, considering the amount of unsatisfied judgments and IRS liens against defendant Kelly. And that is what I got to say about that. Now, what was interesting, or for those of you, who haven't been following along, there's a girl, Heather Williams, who was part of the Cook County indictment that has been dismissed. He's not going to go to trial in Chicago for these 4 individuals, but Heather Williams was one of those individuals, and she filed a lawsuit against Mr. Kelly while he was locked up. And because he couldn't deal with it, didn't have, he kept going through legal representation, kept getting it pushed out. And then finally, his case started in New York. So she got a default judgment of $4 million. And then the company that owned the building where his recording studio was located, they did the same thing, filed a lawsuit. Actually, I think they filed their lawsuit before he was arrested, but he chose to ignore it and not deal with it. And they were looking for like $360,000 for back rent and to restore the studio. So they ended up also with a default judgment, because by the time, everything went going, he was on trial in the Eastern District of New York. And so he too was given a $4 million judgment. So that's $8 million. And then he owes the IRS. At the time he was arrested, he owed the IRS like $1 million, but I'm thinking now it's been 4 years, so ain't no telling how much he owes. But Sony said he only had $150 million that they were holding in royalties. And I think at this point, Sony has pretty much figured out a way for him not to earn. Like, even though we're listening to the music, they figured out a way for him not to be earning any royalties, because they are not trying to give these hustlers any money. So there is no money, child, for y'all to get. Rashona, check out my last video. She trying to get $20 million. Okay, so let's see. What is this document? Okay, this was the government sentencing memorandum. I'm not going to read this because you guys can pretty much imagine the nastiness that they have put in their document. 37 pages of nonsense. Okay, and let's see. And then this was a response to restitution. Let's see. And actually, she put out 2 documents about responding for the restitution. Let me see. I'm not going to read this. I'll do this in a different video because I want to wrap this up at 2 hours. And I'm at 2 hours and 36 seconds. But let's see what this is all about for a second here. Defendant Kelly's memorandum regarding restitution. The government, I think I already read this, child. This is where this girl trying to get this money. Let's see. On February 3rd, 2023, the government submitted a supplemental memorandum to probation related to restitution. Specifically, the government seeks $12,728,416 for restitution on behalf of Rashona. According to the government, Rashona should receive $4,569,851 for lost wages. Girl, she was never going to earn no $4 million. Future life care in the amount of $7,704.97. Medical costs totaling $400,000 and attorney fees in the amount of $54,468. The government did not produce a single receipt for actual losses, but relied entirely on 2 expert reports from a forensic pediatric expert. Okay, so this is that a lot of that I covered in that video I did on Rashona already about her and how she's trying to get this $20 million. Then it goes on to say the government also seeks $291,788 for restitution on behalf of Pauline. Without producing a single receipt or any documents whatsoever, the government seeks restitution for Pauline for lost income in the amount of $50,000, past medical expenses in the amount of $42,000, future therapy in the amount of $149,760 and $28 to obtain medical records. With no supporting documentation, the government seeks restitution in the amount of $80,640 for Mya for future therapy costs, even if the government offered some reliable evidence of losses approximately caused by Kelly's conduct from 1996. It would be offset by the $500,000 Mya already received from Kelly in connection with a civil lawsuit she brought against him in 2002 related to the exact conduct for which he was convicted in this case. And we are going to end it there. Come back tomorrow and we will talk about the sentence, because the sentencing is tomorrow, what the sentence turned out to be and what the restitution turned out to be. And then I will also I'll do another video while this is loading, finishing up reading this document here. But at the end of the day, the man should not get, I'm thinking, I agree with the 10 years, and the 10 years should run concurrently. And it definitely should not be 25 years on top of the 30 years he's already been sentenced. And if you're going to do that, then we need to hear some indictments coming down on some of these other people. And you guys already see how we keep hearing about George Foreman. Then somebody else was in the news recently about some old allegations, but it's always black men that they keep coming up. We need some equal justice here. Go after some of these white folks, okay? Put them on trial and give them 30 years, and then we can talk. So, guys, that's it for me. Go ahead, leave your comments below, rate the video, subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.